Hello, everyone. I'm Karen Rosen. Thank you for attending today's webinar. Elected officials who have registered will receive 1 university credit. Today's webinar is being recorded and will be posted to our site, www.cml.org, under training materials in the next week. For those of you who aren't familiar with the webinar format, you should see a control panel to the top right of the screen. You have an orange arrow to the left of the panel, which will minimize the entire box. All participants will be muted for the webinar, but are encouraged to ask questions by typing them into the question box on the control panel. We will hold a Q&A near the end of the webinar, but please feel free to type in the questions as you think of them throughout the presentation. Today's webinar is being presented by our stellar CML advocacy team. I'm going to turn it over to Heather Stoffer, Legal Advocacy Manager, to get us started. Thanks, Heather.
Awesome. Thank you, Karen. Hi, everyone. Thanks for joining us today. As Karen mentioned, I'm Heather Stoffer, Legislative Advocacy Manager for CML. I'm joined today by my colleagues on the advocacy team, Jacqueline Turway, Molly Steineman, and Megan McKillop. Also, we have our legal team, Rachel Bender and Robert Sheasley with us, but they have turned their cameras off because they're eating lunch. So just know that they're there. So the lobbyists and I are going to give you an update on bills we're working on. To give you an idea of where we are in the calendar and the session, there are 32 days left in the legislative session, including today. Last week, the House passed Senate Bill 214, which is the annual budget known as the long bill. Now that the budget is passed, the Appropriations Committee will divvy up the remaining money to fund various bills. So we'll start to see a lot of bills that were parked in appropriations start to move or die, depending on the fiscal note attached to them. Things are going to speed up significantly from this point on as the majority tries to get their bills passed and through the process before the last day, known as sine die. We will also likely see an effort from the minority party to try to slow the process down significantly, as any bills that are left on the calendar after midnight on May 8th will die. So they're looking to take as much time as possible to try to create a backlog so that bills will die on the calendar. So, and that also gives them some negotiating power. So we'll see a lot of those negotiations just starting to take place. The Democrats in the House have already instituted Rule 14, which limits the debate time to try to combat the filibusters from the Republicans. So it should be pretty wild from here on out. I expect that they'll probably work most of the weekends until the end of the session. There'll be a lot of late nights coming up. And they're still introducing bills. So we're going to keep a close eye on what's going on. And we'll be there probably the whole time till the end of the session. We have an active positions on 84 bills right now, and we're following 260 bills. So we're not going to get to touch on everything today, but please feel free to ask us questions if we did not talk about a bill that you're interested in. You can also take a look at our bill list, which is on CML's website on the advocacy page. With that, we'll start with Jacqueline Turway.
Thanks, Heather. I'm going to go through my bills, like she said, pretty quickly. So if you have questions or confusion or anything like that, please feel free to type in the chat and we'll get questions answered. So the first one is House Bill 1017, the Electronic Sales and Use Tax Simplification System. What this bill is trying to do is to make it even more simplified. However, the fiscal note came back really high. So we have been working with the Department of Revenue, Simplify Colorado, which is one of the proponents of the bill, and some of our sales tax committee members to find ways to reduce that fiscal note with the sponsor. So it got through its first committee hearing, but it's still waiting to be heard in the Appropriations Committee, and we are actively working on trying to reduce that fiscal note. The second one, House Bill 1091, is the continuation of child care contribution tax credit. We are supportive of this bill as well. This would continue the contributions to child care facilities, allowing for a 50% tax credit, whether or not it's a nonprofit child care facility. This bill extends it for 3 additional years, and there's an amendment going through. Currently, it allows for in-kind donations of land and renting, reducing rent. It's going to have an amendment that would study that issue so that we can figure out if that can actually be done through the Department of Revenue. Another bill is 1234, House Bill 1234, streamlined solar permitting and inspection grants. We support this one as well. Solar App Plus was created by NREL, and it allows to have electronic permitting of the rooftop solar in your community without having to go through the in-person process. So what this would do is give a grant of $1 million total to be divvied up between municipalities that are interested in having the program for technical assistance to implement that. A bill that just passed the Senate but is moving into the House shortly is Senate Bill 53, restricting governmental non-disclosure agreements. This bill currently would not allow for us to have any form of non-disclosure agreement for incoming employment or with settlement agreements. This bill passed the Senate unanimously because of the transparency in government piece as well. It's moving to the House, but the sponsors in the House are very open to working with us, as well as the governor's office, who still continues to have problems with the language, which we have provided language to the sponsors as well as the other stakeholders on the bill, and we're waiting to hear back if they're going to accept that or not. So currently we are in an opposed position on that one. Senate Bill 58, Job Application Fairness Act, we had that committee hearing this week. We are currently neutral on the bill because they added an amendment for us. What this bill does is does not allow you to ask age, date of birth, or the date of graduation from any education institution on the initial application for employment. The amendment that we got offered is that we can request certifications, transcripts, or any other materials such as licenses or finalizing coursework or things like that, as long as we tell the applicant that they are permitted to redact the information that would be age identifying on those. So we can still assess qualifications prior to moving into the next interview process. So we, again, are neutral on that one now. Another bill coming up this week on the Senate floor is Equal Pay for Equal Work, Senate Bill 105. We still have concerns about this language and are currently in an opposed unless amended position. This makes some cleanups as far as notification process and allowing for employees who are simply moving up in a job opportunity to not have to go through the full application process that the Equal Pay Bill instituted a few years back. However, it's unclear with the language if the notifying of the other employees in the company would occur with, my apologies, would occur with demotions as well, and not just promotions, which is concerning for us. Also, the back pay, if you're found to be not in compliance with this bill, is currently 3 years, and it would move it to 6 years, which is an increase that is significant enough for us with taxpayer funding that we are asking for that to be remaining at 3 years. Senate Bill 108, we are supportive of. It's allowing temporary reductions in property tax due. What this would do is if your municipality is trying to reduce property taxes and your council has voted on that to do a temporary reduction, you would not have to hold a Tabor vote of your constituency to raise it back to the level that it was at. It's unclear in the statute right now whether you would need a vote or not, and I know that many of our municipalities that have done that have held a vote to go back to their originally instituted levels, but this would clarify that you would not have to do that and not have to spend that money on that. Senate Bill 111, if you've read any of our information over the last few months, Senate Bill 111 is covered in there. This is the Public Employee Workplace Protection Bill. We are opposed to this bill. It would require local governments to not interfere with, dismiss, have any form of repercussions for individuals who speak out about workplace concerns, workplace issues, participate in protected concerted activity, or participate in the political process in any way. And that one is the only one that is defined as being off duty. We have significant issues with this because, as you all know, municipalities are nonpartisan elected officials and should be a nonpartisan working environment. And we have concerns about the bias that this would create, as well as allowing people to engage in activities that aren't actually defined. So not sure what a workplace issue is or what a workplace concern is, how big of an issue it would have to be for them to be allowed to talk about it in any time of work. We have received multiple letters from municipalities that have taken opposition positions or amend positions to be able to share with legislators. So if you all have taken a position in your municipality, I would love to hear from you and love to get some form of communication stating that, so that we can help share that with our senators right now that we are trying to get to vote to remove local governments from this bill. Also this week was the Senate Bill 172, the Protecting Opportunity and Workers' Rights Bill, or the POWER Act. This updates the harassment definition in the workplace and changes it to an affirmative defense for the employer, as well as removes the language around severe and pervasive, and has a completely new standard. We are opposed to this bill, and we are still working on remaining the severe and pervasive language, and then working with a few other things with affirmative defense, as well as record keeping issues that are in the bill as well. So that did pass committee, but we are working on it still. The next one is Senate Bill 183. We are supportive of this bill, and I want to make sure you guys all are aware that the local government provision of communication services, it's passed the Senate, and we are moving into the House. But what this does is remove the requirement for local governments to hold a vote to be able to utilize taxpayer dollars to invest in broadband infrastructure, either providing it for your citizens as another utility or in investing in middle mile or anything like that. So currently right now with Senate Bill 152, you do have to hold a vote for that, and over 120 of our municipalities have already voted to be out from under that. This bill would remove the requirement for the vote. So we are very excited about that one and supportive of that, and hopefully that will continue through the process. And then the only other thing I wanted to touch on is property tax. It was brought up in the governor's State of the State speech. And we have been meeting with groups every 2 weeks since basically the beginning of session on what is going to happen on property tax. We have not heard or seen anything yet. So we're thinking, even though we were attempting to work with the governor's office on making this one of the earlier bills so we could actually negotiate it out and figure it out, that it's going to be a last minute thing like it was the last few years. And we're hopeful that it will be a more permanent fix than the temporary one that came through last year, but it's unclear at this time. So stay tuned to our State House reports. I'm sure we will share that once it comes out, since it is so much of an effect on all of us. So that is my report. Thanks.
Awesome. Thank you, Jacqueline. I'll go next. So first I want to start off with some elections bills. House Bill 1185, this is recalls and vacancies. This is one that CML is supportive of. It's CML initiated legislation, and it makes technical updates to Title 31 recall election statutes. We added language to the statute to address vacancies. There have been situations in which city councils will have mass resignations, and there's nothing in Title 31 that directs a clerk or anyone else on what to do when that happens. So this would allow, we added language that would allow the clerk to call for an election in the if there is not a quorum. The bill also will require recall committees to be registered electors of that municipality. There have been instances in which outside groups will come into municipalities and initiate recalls. They fail miserably, and the city is left paying for expensive special elections. So we figure if you can't find 3 registered electors in that city to be part of your recall committee, you probably shouldn't be running that recall in that community. So that passed Senate third reading on March 31st and has since been signed into law. So I'm very happy to report that. House Bill 1245, this is campaign practices for municipal elections. CML is opposed to this bill. It sets limits on campaign contributions for candidates in municipal elections, and this excludes any home rule municipalities who already have campaign contribution limits, and if they're exempt from the Fair Campaign Practices Act. However, notably, if you are not exempt from the Fair Campaign Practices Act, this would apply to you. So check on that and make sure that you are exempt or know whether you're exempt or not. So the aggregate limit for contributions set per person per election cycle is $250. The aggregate limit that is set on contributions to candidates from small donor committees is $2,500. The bill requires campaign contribution reports for candidates to be filed no later than 60 days, 30 days, and 15 days before the election and 30 days after the election. This is an increase. Right now it's 2 periods per election cycle. So this would be an increase in reporting requirements, which could put burdens on the clerk, especially if you're in a small community. The bill extends the retention requirements for campaign contribution reports from 1 year, which is what it is now, to 10 years after the person has left office. We think that that's excessive and will also create burdens on the clerks. The bill also requires that municipalities provide free reports, disclosures, or statements. And it removes the authority to charge an hourly fee that's currently under the Colorado Open Records Act, but it does allow the clerk to charge a fee for paper copies. There were amendments added to this bill that exempted communities under 1,000 from the provisions. It also added language that address runoff elections. So the filing dates for runoff elections are 15 days before and after the election. Representative Wilford in the House is going to seek amendments based on our concerns with the language around the inspection of records. Instead of requiring free inspection of the records on a website, it instead allows free inspection of the records if they are on a website or if you go in person. We would be able to charge research and retrieval fees just like now for Cora for large requests and a fee for paper printouts. She also wants to seek amendments that would lower the retention period from 10 years to 6 years. So she's negotiating with the bill sponsor on that, and hopefully we'll see those amendments go on second reading in the House. We still have concerns with the bill, but that will make it a little bit better. Switching gears to governmental immunity, House Bill 1032, this is remedies for persons with disabilities. CML is opposed to this bill. Currently, under current law, it says that a plaintiff who is seeking a discrimination claim is entitled to any of 3 remedies, either a court order for compliance, actual damages, or a penalty. This bill changes it so that you can get a court order and either actual damages or a penalty. So if you have a low-level curable issue, which could be remedied by a court order alone, you wouldn't be able to just get a court order to cure that issue. It also changes, it would also allow emotional damages to be available for a disability discrimination claim. Current law also awards attorney's fees to prevailing parties. This bill would change it so that only a plaintiff can be awarded attorney's fees. And it allows claims to bypass any administrative processes and go straight to court. So we have a lot of concerns about that. We think that it really encourages lawsuits that maybe have no merit or standing to occur, and really doesn't allow those low-level issues to be cured through administrative processes. The bill also, I'll just mention, includes places of public accommodation to state anti-discrimination provisions, which is a bigger deal for private entities, not so much for public, because we already have to abide by that. So this bill has been hanging out on second reading calendar for some time now. There's a strike below amendment that I understand will be added to the bill when it is heard on second reading. The strike below amendment would take out references to emotional damages. It would take out the attorney's fees provision, which is all good things. I think that this bill is being held as part of a larger negotiation around some of Representative Ortiz bills. So we'll know more about that, but that's just been kind of hanging out on the second reading calendar. I'll mention the other two bills that Representative Ortiz is running around building codes. This is a housing accessibility. CML is opposed to this bill. It would require all new construction projects to provide at least 15% dwelling units that meet specific design criteria for people with disabilities, and requires builders of projects to create an implementation plan that guarantees timely and evenly phased delivery of the required number of units. The standards apply to both private and public housing, with an exception for privately funded projects that provide 3 or fewer detached residences. So this is a big change from what's currently required under ADA. State and local government can grant an exception under this bill to the accessible housing standards if they determine that the standard or specification is technically impractical or would create an undue hardship. However, this determination has to be in writing and articulate the relevant undue hardship. And if a state or local government fails to require the implementation plan or ensure compliance before a building permit is issued, we can be liable for a discrimination claim under those provisions. So it will really open us up to additional liability and add significant costs to local affordable housing projects. So as I mentioned, this is a draft. It has not been introduced, and I think it's part of a larger negotiation with the governor's office at this point. So I will keep you updated on what I'm hearing on that bill, but we do have concerns about the way that it's drafted currently. Similarly, state and local government accessibility bill, this is a draft as well. The current draft requires that in 6 years, local governments have to ensure that every building where they conduct business has to be fully and independently accessible by a person with a physical disability who uses a mobility device. It also requires public business has to be accessible in real time, live streaming video and audio. You have to require to allow any person to participate in the meeting and offer public testimony with the use of video conferencing platform at the same time as people who appear in person. It would require auxiliary aids and services when requested, and failure to comply with any of those provisions would create would constitute, a discrimination claim in which the person is entitled to seek relief. This is a huge undertaking for every building to become completely accessible within 6 years. So we are opposed to this just based on the infeasibility of actually getting to completely accessible within that time frame. I have heard that the latest draft of this bill that I haven't quite seen yet has moved the implementation date from 6 years to 20 years. So I'm waiting on that updated draft to see if they've made any other changes to the bill. But as I mentioned, this is part of, I think, larger negotiations with the governor's office. So I'm sure we'll see something soon on that. The last piece on building codes that I'll mention is House Bill 1057. This is amenities for all genders in public buildings. CML is opposed unless amended on this bill. This bill got a strike below amendment in committee and requires that by January 2024, each building that's wholly or partially owned by a public entity has to provide a non-gendered restroom facility on each floor where restrooms are publicly available. So that's either newly constructed buildings, or if you are making a renovation to a restroom, you either have to provide a new restroom or make adjustments to allow multi-stalled restrooms to become gender neutral and meet specific plumbing designs on that. It allows there's also requirements for baby changing stations in restrooms that are newly constructed or renovated as well. And then the bill allows an employee to undertake a complaint process for failure to comply with those, providing those amenities. We're concerned about the increased cost for renovations, as it's not always practical or possible to create a new bathroom in certain situations, and the increase in liability for public entities. So what we've asked the proponents is that they limit this to new construction so we can properly plan for providing those amenities. This bill has been parked in appropriations for a very long time. It has a $2.3 million fiscal note attached to it. So I assume that it will be heavily amended or it will not make it out of appropriations. So more to come on that one. Let's go to wildfire. House Bill 1174, homeowners insurance underinsurance. CML is supporting this bill. It requires insurers to offer guaranteed replacement cost coverage to homeowners, and it requires the Division of Insurance to publish an annual report on replacement costs. This is also waiting in appropriations for a hearing. We heard from folks very early on in the session that underinsurance after disasters in particular was taking a toll on their communities. So we're supporting this bill and we'll help it make its way through the process. House Bill 1240, sales use tax exemption, wildfire disaster construction. CML is also supporting this bill. It creates a state sales and use tax exemption for construction and building materials purchased on or after January 2020, but before July 2025. And it's for materials that are being used directly for rebuilding or repairing a residential structure that's damaged or destroyed by a wildfire, either in 2020 through 2022. So this allows a local government to also exempt sales tax, but it does not mandate it. So this is waiting in appropes as well. I expect that to move soon, and we are supportive, as I mentioned. Senate Bill 166, the establishment of a wildfire resiliency code board. This has been something that we've been working on since before the session started. We're opposed to this bill. It would create a wildfire resilient code board in the Department of Public Safety, and they would be tasked with defining where the wildland-urban interface is, and then creating minimum building codes for that local governments would have to adopt within the wildland-urban interface. Local governments, you could petition the board for a modification of the codes if you already have codes that address wildfire. This is pretty burdensome and creates a lot of additional work for local communities. The bill has some momentum, but notably within the committee, when it was heard in Senate Local Government Committee, affordability concerns were brought up. So we're going to continue to lobby against that bill as it makes its way through the Senate, and see if we can get some amendments added onto that give local governments a little bit more flexibility in implementing those codes. Open meetings and open records, House Bill 1259. This is open meetings law executive session violation. So this bill creates a right for a local public body to cure a violation of the open meetings law with respect to an executive session if the local public body takes the corrective action at its next meeting. This is really coming from school districts who have had a problem with these kind of predatory lawsuits where an attorney will listen into their meeting, and if let's say a board member misquotes the statute or there's a minor violation of open meetings law, the attorney will initiate a lawsuit, they'll settle out of court, and that attorney will take their money and move on. So to kind of discourage those types of lawsuits, which really aren't in the spirit of the open meetings law, this would create a cure process. Notably, you know, this happens a lot with school districts. It does happen sometimes with municipalities as well. So we're supporting that bill as it moves forward. And I believe that that's going to be in the House Local Government Committee, excuse me, State Affairs Committee next week. So we'll be supporting that. The Colorado Open Records Act bill. So this is one that we've been hearing about for a very, very long time. It has still not been introduced. I do expect it to be introduced shortly. We just got the new draft, and it did not include fee exemptions for the press, which was our largest concern with the previous drafts. So it makes a number of changes to CORA, which are not as concerning. It essentially, it says that if a record's available and can be transmitted in digital format, a custodian is required to transmit it in electronic format unless it's otherwise requested. CORA statutes currently allow a custodian to deny a requester's right to inspect certain records on the ground that disclosure would be contrary to the public interest. The bill also includes in this category the telephone number and home addresses of an elected official for the future of future communication with that elected official. So if somebody's trying to harass an elected official, you can deny those records. The bill specifies that if an elected official is the subject of a government authorized investigation into the elected official's alleged sexual harassment, I should say, in the workplace, the final report of that investigation is a public record. And the bill specifies that the custodian cannot charge a per page fee if the records are provided in a digital or electronic format. The only other thing in this bill is it requires, if you allow credit cards for payment for anything else, you have to allow a credit card payment for a CORA request as well. So we have suggested a few amendments to that just to really ensure that witnesses are protected with investigations, making final reports of investigations public records, and there's some changes that need to be made with that. But overall, the main concern with that, with the press getting free research and retrieval fees, is taken care of. So that's encouraging. So I expect that to get introduced soon. House Bill 1248. This is a very weird bill. It's Executive Committee's investigatory authority. CML is opposed to this bill. It authorizes the Executive Committee of the Legislative Council to create ad hoc investigatory committees and grants the Executive Committee the power to subpoena a witness, to take testimony under oath, to assemble records, documents, and evidence by subpoena. The bill also requires the Executive Committee, if it decides not to issue a subpoena under its own discretion, to issue a subpoena if 30% or more of the voting members of an ad hoc investigatory committee vote to require the Executive Committee to do so. We're very concerned by this. It's what I would say is arguably a violation of the separation of powers clause of the Constitution. We're concerned that municipal elected officials and staff could be subject to these investigations and subpoenas. And it's just a broad overreach of legislative authority. So we are opposed to that bill. I believe that's up in committee on Wednesday. I don't believe that there's much enthusiasm for it. So we'll see what happens with that, but we will testify in an opposed position next week. And then the final bill that I'll mention is Senate Bill 244. This is technology accessibility cleanup. So this is stemming from House Bill 211110, which created requirements for accessible websites for local and state governments. The bill makes modifications to that statute, and it, among other things, it requires a formal rulemaking by the Office of Information Technology to adopt standards. It clarifies that state and local governments must provide digital content and inserts the word reasonably, that reasonably enables an individual with a disability to access the same information, and that's very key. The bill also limits the violations to a single incident per platform. So you couldn't go on a website and if there's 3 incidences, you get to collect $3,500 for each one. It's per product, per website, or per application. And so this gives more protections to local governments as they work to make their websites accessible. I think the rulemaking in this is very key because I think a lot of the concerns that we have encountered around the accessible websites can be figured out through a formal rulemaking process as well. So That's all I have. I will pass it on to Molly.
Good afternoon, everyone. Happy to be back in a webinar with you all. I'm going to kick things off with some criminal justice updates, starting with some good news with House Bill 23-1169. This is limit arrests for low-level offenses. This bill would have prohibited the use of arrests for low-level offenses like petty offenses and municipal offenses for which there's no comparable state charge. And it would have instead required a summons in lieu of arrest. We heard a lot of concern about this proposal from our law enforcement stakeholders, really based on a public safety perspective. There are instances in which an individual is committing a petty offense where if they refuse to stop that behavior for whatever reason, whatever they were doing would potentially pose a risk to broader public safety. So we were opposed based on that standpoint. This bill was postponed indefinitely, and it did die earlier this week in House Judiciary. The sponsor was willing to work with us, but unfortunately none of the amendments that she was considering would get this bill to a place that we would have been comfortable with. So we were grateful that she took our concerns into consideration and decided to postpone the bill herself. I will say, just for general awareness, there are several members of the House that have indicated that they would potentially like to take up this issue in future legislative sessions. So I don't think that this is the last that we've heard of this type of proposal coming before the legislature. Moving on then to House Bill 1249, reduced justice involvement for juveniles. This is the raise the floor bill that many of you may have been familiar with because of a similar proposal that was brought before the legislature last year. But essentially this bill eliminates municipal court jurisdiction over juveniles aged 10 to 12 for all municipal ordinance violations, whether they're classified as civil or criminal, and regardless of whether that municipal court has a pretrial diversion program. Instead, offending juveniles would then be referred to a local CMP for the service and support team to create a service and support plan for the offending juvenile. CML is opposed to the bill because of the elimination of municipal court jurisdiction and because it's our belief that juveniles already have robust access to services through pretrial diversion programs. This bill was heard in the House Judiciary Committee earlier this week, and there were a few clarifying amendments adopted to the bill, but it's nothing that addresses our primary concerns. And at this point, we do anticipate that the bulk of the progress that can potentially be made on this bill will probably happen in the Senate and will probably happen in the Senate Judiciary Committee, depending on where the bill is routed once it gets over there. So more to be seen on this one. We did testify opposed, and we're willing to have those conversations, but we would like to see some pretty significant amendments to that bill in order to feel comfortable with it. Transitioning then over to beer and liquor, House Bill 1061, alcohol beverage retail establishment permit. The goal of this bill was essentially to expand the existing gallery permit to include small business retailers so that they can offer complimentary beverages for a limited set amount of events throughout the year. We successfully lobbied that bill for an amendment to increase the local application fee from $100 to $200 to offset the anticipated workload increases with the bill. Right now, when I reached out to the municipal clerks, there were several that said that they didn't have any gallery licenses or they had like one or two. So the expansion of retail businesses into this type of permit would have been a pretty significant increase in workload. Once we got that amendment, CML then moved to a support position on the bill because of the potential downtown revitalization and economic benefits to communities. It passed out of the House with tremendous support and has been assigned to the Senate Business Committee. And then Senate Bill 171, large entertainment facilities, substance-free seating requirements. This bill also was postponed indefinitely recently, but it would have required venues with 7,000 seats or more to reserve at least 4% of those seats for substance-free seating. And there was some language in the bill that required that the substance-free seating locations couldn't be disproportionately worse than other parts, so you couldn't like stick it up in a corner of the venue. We were opposed to the bill because there are some municipally owned facilities that would have fallen under the bill and they would have had to make those changes, but mostly because of local licensing agencies' bandwidth and the fact that they would have had to change their existing policies to adjust to these changes without any funding within the bill for them to accommodate that. So we were opposed and the bill luckily did die and we testified in committee against it. Transitioning on then to public safety, House Bill 1167, reporting of emergency overdose events. This bill does two things. It fixes a minor drafting error that took place in last year's comprehensive fentanyl bill, House Bill 1326, and it does expand the existing Good Samaritan protections to drug distribution charges. So essentially, if an individual acts as a Good Samaritan when they are with somebody who is experiencing a drug overdose, they would have Good Samaritan protections expanded to them for the possession of the drugs, but also for the underlying distribution charges that they were the one who was sharing the drugs or distributing the drugs at the time of this individual having an overdose event. CML is in a support if amended position on this bill. We appreciate the efforts to fix the drafting mistakes in last year's bill, but we see the expansion of Good Samaritan protections as sort of a renege on negotiations and agreements that were made in last year's fentanyl bill, and we would like to not see that expansion. This bill has made it through the Senate on second reading, and it does have a pretty clear path to signing. So at this point, we're just having those conversations still about our concerns on the bill. House Bill 1230 prohibit the sale of assault weapons in Colorado. CML is neutral on the bill, but I heard a tremendous amount of feedback from people when this bill was originally sort of being workshopped, so I wanted to make sure we had an update on it. We worked with the sponsors to remove the concerning law enforcement language from the bill prior to its introduction. So at this point, we are just taking or keeping an eye on it. The outcome of this bill looks pretty rocky. The House sponsor went against leadership's wishes and introduced the bill before they would have liked her to, and the governor has already signaled his willingness to veto the bill. It was assigned to the House Judiciary Committee a few days ago, but then it was then moved from the calendar and has not been placed back on for a committee hearing. And we've heard the sponsor say in recent days that she's considering PIing the bill and killing it herself due to strong opposition. So the outcome of that, or the future of that one, doesn't look very promising for the bill's passage. Senate Bill 109, criminal penalty controlled substance supplier. This bill makes it a level 1 drug felony for drug distribution resulting in death. There is already a level 1 drug felony for fentanyl drug distribution resulting in death, but this bill would essentially expand this out to all other drugs. CML supports the bill as a reasonable step towards mitigating the drug overdose crisis in our communities, and we would like to see that one pass to fruition. It made it out of the Senate, but it's going to have a much harder time in the House because there are several House members that are ideologically opposed to anything that's increasing criminal charges right now. It has not been placed on the House Judiciary calendar yet, and that is really just because the House Judiciary Committee has a pretty significant backlog of House bills that it needs to work through before we can actually get to the Senate bills that have been assigned to that committee. Moving on then to Senate Bill 97, motor vehicle theft and unauthorized use. This bill decouples the charges associated with motor vehicle theft from the value of the stolen vehicle, which is what is in current law. The bill then establishes that motor vehicle theft in the first degree is a class 3 felony, theft in the second degree is a class 4 felony, and theft in the third degree is a class 5 felony. We support the bill because our executive board has made it very clear to us that they would like to see us proactively and positively engage in proposals that aim to manage and mitigate vehicle theft in the communities across the state. Like the other Senate bill, this one has not been placed on the House Judiciary calendar, but pretty soon we expect to see it pop up. Senate Bill 149, false reporting of an emergency. This bill extends swatting provisions to include fake reports of mass shootings and makes it a class 6 felony to falsely report an active shooter. We support the bill. I'm sure everyone remembers several weeks ago when there were a series of mass shooter swatting calls placed to high schools across the state. Swatting calls generally just waste law enforcement time and resources, and we would like to see this bill as the next sort of natural step in taking care of the swatting calls that are being placed related to active shooters to schools. This bill is going to be in the Senate Judiciary Committee next Monday, and CML will be there testifying in support. The last one then for public safety is Senate Bill 254, search warrant procedures. This bill changes the standards for conducting no-knock warrants and requires that there be an affidavit establishing that a no-knock entry is necessary because of imminent danger to the life of any person, including the executing law enforcement officers. There are then additional provisions placed on knock and announce warrants to include permissible hours of execution unless a judge authorizes execution outside those timeframes. There are requirements that officers be in uniform and have their body cameras employed. And there is somewhat confusing and problematic language that requires law enforcement officers to knock loud enough and wait a reasonable amount of time to reasonably assume that someone has heard their knock and has then had the time to move within the dwelling to answer the door for them. We are opposed to the bill unless it is amended. We're partnering with our friends at the Chiefs of Police Association to advocate for something in the bill that would essentially create allowances for officer discretion when executing these warrants, which doesn't currently exist, and some cleanup language to clean up the entry requirements and make it a little bit more clear as to what those requirements are, and also then less burdensome for law enforcement to implement these into their existing policies and procedures. And then finally, I'm going to wrap up with a very brief regulated substances update to cover psilocybin. When we had our webinar earlier in the legislative session, we indicated that it was CML's goal to have CML initiated legislation to include a greater degree of local control in Prop 122, which passed earlier by the voters this year. The concern is that psilocybin now is sort of not in alignment with retail marijuana, and that local governments do not have the ability to opt out of having it completely within their communities. The governor's office is very opposed to that idea. They do not want to see really any degree of local control placed into this bill. And the reason for that is because they would like to align with what the voters have voted and have approved this past voting cycle. So we believe that there will be a bill this year regarding psilocybin and regarding the implementation of psilocybin regulations in the state. But it's our belief at this point, because of strong opposition from the governor's office and because of strong opposition from Senate leadership, that introduced bill will likely not include the local control language that CML wants. That being said, we will continue to have these conversations, and we will continue to meet with the bill sponsors to advocate for the use of local control with psilocybin. And if there is a bill introduced that does not contain the local control element, we would work to try to amend the bill to clean it up in a way that works well for us. So those were my updates. I'm going to go ahead and pass it over to Megan.
Excellent. Thanks, Molly. And thank you all for hanging in there. I'll try to be brief so we can have some time for questions. And I'm just going to go through the list numerically, so a little bit different. So I'll start off with House Bill 1132. This is a priority bill for CML that was initiated through our policy process. It creates a task force within the Judicial Department to examine the feasibility of expanding communication between municipal courts and state courts. Currently, municipal courts all have their own systems, and state courts, such county and district courts, are on their own system. And it's really difficult to see case dispositions or pending cases and activity going on between all of those different courts interacting together. So that bill passed out of the Senate Judiciary Committee and is headed to the Appropriations Committee, and it should be voted on by that committee on Tuesday. The bill was already fully appropriated in the House, so this should sail right through Appropriations and then head to the floor for a vote. Next bill I would like to talk about is the House Bill 1182. This bill would grant remote public access for criminal court proceedings for municipal courts as well as state courts. The bill is written provided that municipal courts did not have to comply with this statute unless they had the technological capability in order to comply. This is problematic for several reasons. It's unclear what technological capability actually meant and what would require a court to comply with the law. We did receive amendments on this bill to clarify that not only does a court have to have the technological capabilities, such as the ability to connect to WebEx or Zoom or even a YouTube streaming channel and things that municipal courts are currently doing, but they also have to have adequate staff on board to run the streaming for the court. So if your court is, let's say, in municipal chambers, city council chambers, I should say, but you don't have staff that is dedicated to running the streaming of your court, you would not have to comply with this law, and you can continue on as you normally would. So nothing would change for you with regards to this bill. As a result of that amendment, the league is now neutral on the bill, and I do understand that our partners at the District Attorney's Council are still working with the sponsors in the House and in the Senate to tighten up some of the language regarding victims victims can be impacted through this bill if a court is required to stream entire court proceedings. It is unclear when a court would have discretion to turn off that proceeding for that is available for streaming. So I know that the District Attorney's Council is working with the sponsors to tighten up that language a little bit, and we will support them in their efforts. House Bill 1190 had its first vote in the Senate this week, I should say. This bill would allow a local government to initiate a right of first refusal on a multifamily property, and this would apply to all local governments throughout the state. The level of the unit thresholds in rural areas and urban areas are different, and there are affordability requirements if a local government does opt to purchase a multifamily building. There were several amendments put on in the Senate Committee of Local Government and Housing, including amendments to shorten the timeline to make it less burdensome on a private seller and to more closely align with a transaction that would happen on the private market. We've also received many amendments on this bill prior to its introduction in the Senate, and that included a provision that would allow, or I should say a clarification that would allow a municipal government from opting out of either the entire provision of the right of first refusal, so a seller would not have to provide notice to a local government when they are selling a building, or parts of this ordinance. So if a local government would still like a private buyer, or a private seller to provide them notice that they are putting their building on the market, they would provide notice to the local government via email or regular mail, and that could be the end of that, or they could have to comply with the entire statute. However, we feel like the amendments that have been put on really do strengthen the bill and make it less burdensome on private property rights. We are supportive of this bill as it is one tool in the toolbox, as we like to say, to provide affordable housing in our communities, which we are desperately in need of. House Bill 1192 is a bill that we recently took a position on it within the last few weeks. This wasn't put on our radar until recently. It is a bill that's brought forward by the Attorney General's office that initiates more protections for the consumer in the Consumer Code. And the first section, there is a section of the bill that was added by the sponsor in the House that would lead to more construction defect damages. And in single family builds, I should say. So we would like to see that section stricken out, as we would like to go the opposite direction and loosen construction defect litigation opportunities so we can provide more housing that is available for purchase, especially in the condo space. House Bill 1202 is local control for overdose prevention centers. CML is supportive of this bill. It went through the House with a great deal of support and is awaiting to be assigned to a committee in the Senate. I believe the sponsors are just holding off to make sure what is efficient enough or what committee would be efficient, and in terms of the calendar. There are still a lot of bills out there, so I think we want to be sure that it just goes to the right committee, but we are supportive of that bill and awaiting it to be heard in committee. House Bill 1222 will have its first hearing next week on Tuesday the 11th. This bill, as introduced, would prohibit municipal courts from prosecuting and charging cases of domestic violence. We have worked very closely with the proponents and the sponsors of this bill to ensure that municipal courts will still have that capability if they comply with the Victims' Rights Act when they are prosecuting domestic violence cases. So we do expect that amendment to go on to the bill, and if that is the case, CML will be supportive of that legislation. House Bill 1233 is a bill that is currently pending second reading, so a floor debate in the House of Representatives. This bill creates electric vehicle charging and parking requirements for multifamily buildings, and we're very concerned about this bill in light of a bill that CML worked very closely with our partners at the Home Builders Association on last year, House Bill 1362, which created energy codes and an energy code board, which is responsible for creating model codes for new developments and remodels as well. This bill really takes EV parking requirements out of the activity that's currently happening at the Energy Code Board, and in our view, reneges on a deal that we made with the sponsors last year. So we're really hoping that the language is amended very heavily, and specifically any requirement for EV parking to be moved up into a sooner timeline we would like to be stricken. So we're hoping that gets done as well. I'll just move into the Senate. There are a few new House bills that were introduced. I'm happy to touch on those as well if you all have questions, but in light of time and knowing that I have a pretty big bill that I think people want an update on, I'm going to continue to move down my list. And I think I'll just skip over to that bill so we can have some time for questions. Senate Bill 213 which is the land use bill, had its first hearing in Senate Local Government Committee yesterday. It was a 12-hour hearing, I think 12.5-hour hearing, where testimony was taken only. We anticipate some significant changes to the bill to be made, and that was noted by the sponsor of the bill, Majority Leader Moreno. And I'm happy to go through the summary, but again, in light of time, I want to make sure that I just give you an accurate update. As you might be aware, the bill contains 4 major preemptions, which would preempt local land use decision-making concerning ADUs, middle housing, which is townhomes, duplexes, et cetera, as well as parking requirements in transit-oriented areas and key corridors, as well as requirements to create more mixed use and dense housing within those areas. So some amendments that the bill sponsor is considering is to strengthen affordability and anti-displacement language within the bill, also revising rural resort community requirements, providing additional flexible in the different housing options for all of the municipalities that would be impacted, and streamlining implementation, as well as strengthening stakeholder input. I want to emphasize that these are just concepts that we have been shown, and we have not seen any amendment language, but we are very much anticipating any amendments that we can have input in. I will also note that we would be very concerned if the land use mandates were lifted for only rural resort communities and not all of the communities within the bill. Not only is that not necessarily a statewide approach, but we do still maintain that resource adequacy for large swaths of density on the Front Range would put a huge strain on our especially water resources that come from the West Slope. So we would be very wary of any language to do just that. So with that, I'll just take some time. I'll pause there to answer any questions. I know we only have 3 minutes left, but we would love to hear any questions that we have.
Okay, great, thank you. We just have a couple of quick questions. One, Heather, what was the bill number for the records and retention processing requests?
Thank you. So that has not been introduced yet. I assume it will be introduced soon. So there's not a bill number associated with it yet.
Okay, and then what have you heard are the next steps for the Joint Select Committee on rising utility rates?
Hi, so at this point, they have held their 3 meetings that they were required to hold, a minimum of 3. They were not given any authority to draft legislation out of that committee. So it's unclear what is going to happen from there, if they're going to continue to study it over the summer, or if somebody that was listening to that committee is going to draft something. But if you guys have any specific requests or things, there are energy bills and electricity bills that are moving through the process that we just currently don't have positions on, but we can see if we can get something put into those if there's a request that you guys have. Thanks.
Great, thanks, Jacqueline. The next question on the Senate Bill 213, any discussion of including counties, at least in Tier 1 adjacent counties?
There has been discussion of incorporating counties and unincorporated areas into the bill, but we have not seen any language to that effect. So stay tuned.
Okay, great. Thanks, Megan. And then the last question, any funding for House Bill 244?
House Bill 244?
That's Senate Bill 244 is the technology accessibility cleanup bill. I don't believe that there's any funding in terms of grant money for local municipalities, but that's definitely something that we've heard people would like, and if it's possible, we will push for it.
And
Terrific.
before we end, Karen, I just want to say thank you to everyone who came out and testified and waited for hours online on Senate Bill 213. For those of you that made long drives, I know one from Crested Butte came down to Denver to testify, but we really appreciate all of the support, and our pressure is working, and our senators are listening. So look out for more updates from me going forward. And I'm so sorry we didn't have a lot of time to discuss it here today.
Okay, I'm going to take one last question. Any information on late bill status for URAs and agricultural land inclusions?
Hi, yes, that would be my issue area. We have heard that it is being drafted. I have not seen it yet, and I do know that they have requested late bill status, but I also don't know if they've been given that. I know Heather talked about the timing and how many bills are left at the beginning of the webinar, and that really plays into what is and is not approved on late bill status. So we will let you guys know if we hear anything on that one.
Okay, terrific. Well, it is now 1 o'clock, and so we want to honor everybody's time. So thank you to our legislative advocacy team for today's update. And thank you all for attending on a Friday afternoon. Once again, we will have this recording up on our CML website under training and materials in the next week or so. So thank you all for joining us. This concludes today's webinar. Have a nice afternoon and a great weekend, everybody. Goodbye.